Well, good morning and welcome to today's Equal Pay webinar. I'm Tim Kellett and I'm from Paydata, and we are a reward management specialist, and we help organisations to find, attract, retain and motivate the right sort of people to be a success. We offer a range of services, but ones which are of specific interest, I think, or relevance today is equal pay audits that we've been doing for over 15 years. We also help organisations to benchmark their salary and benefits against the external market. So obviously job matching and levelling is important in that, and that's where our job evaluation system, our pay grade job evaluation system, comes in to play as well. And that's obviously very important when people look at equal pay audits as well. So that's of relevance. Now, that's of relevance today. I'm delighted to introduce a colleague of mine, Jane Fielding, who's a partner at Gowling's international law firm, who specialise in helping organisations with employment, labour and equality. So obviously having her experience today is going to be really, really useful for today's session. In terms of what we're going to cover in the next hour, we're going to start off by talking a bit about gender pay and equal pay and the differences between the two, because people often get the two mixed up. So Jane will be starting things off with that. Then I'm going to be talking a little bit about equal pay audits and the sort of best practice, the pitfalls, the challenges people face and how to overcome them. I'll then hand back to Jane, who will talk a little bit about legal privilege and how the role that has to play in terms of equal pay audits. Obviously, if you get an equal pay claim, how you manage that, and then we hope to get some questions at the end of the session for 10 minutes. If we run out of time, we've got a hard stop at 10 o'clock, so we'll note down any questions and answer them and send those out as answers afterwards. We will be sharing today's slides, and we are recording today's webinar, so if you feel that your colleagues would find it useful, we'll send out the link as well. So I hope you find today's webinar useful, and I'm going to hand over now to Jane to talk about the differences between gender pay and equal pay. So over to you, Jane.
Thanks, Tim. Morning, everybody. So I'm going to explain and help you understand the difference between gender pay gap reporting and equal pay by giving you an overview of each of them and explaining why, as Tim says, they're not the same thing, although they are clearly related. They're both complex areas of law, and in particular, the gender pay gap reporting regulations are quite fiddly. And those of you who are already reporting will probably be familiar with that, although by now we've had it a few years, so maybe you're used to what you have to do to report in a compliant way. But basically, the gender pay gap is a basic measure of the average differences in pay between male and female employees in a particular organisation. And that's expressed as a figure representing women's pay as a percentage of men's pay. So if you have a positive percentage, plus 7%, for example, that means that women are paid on average less than men across the organisation. If it's a negative figure, then it's the converse. The women are being paid more on average. And if in the unlikely event, although it does sometimes happen, you have a 0%, that means you've at that particular point in time not got an equal pay problem, not got a gender pay gap problem at all. So the gender pay gap regulations require employers who are caught by them to report the data at a snapshot date. And for private sector employers, that's the 5th of April each year. If you're a public sector organisation, it aligns with the financial year, and that's the 31st of March snapshot date. And if you're part of a group, then each group company which meets the relevant threshold, which is 250 employees employed on that snapshot date, has to publish its own report. Now, in groups, we often see voluntary reporting at a group level, so aggregating the figures for the different legal entities, but that is only voluntary, and obviously it's a judgment call depending on what the story tells at a group level. Generally, if it's more positive, it's reported. If it's not, perhaps it isn't. And the deadline for publishing that data is in the current year, we're in the 4th of April next year, and then every subsequent 4th of April. If you're private sector, if you're public sector, it's the 30th of March to align with that 31st of March snapshot date. So what does the report have to include? Well, there are 4 compulsory elements, which I'm going to talk you through, and 1 optional one. So the first thing is it has to report the difference between the mean and median hourly rate of pay. Now, there's a specific statutory formula for calculating the hourly rate of pay, which we don't have time to cover now. And the regulations also specify what elements feed into pay. So it's, for example, basic pay does, overtime doesn't. Holiday pay while you're on holiday does, pay in lieu of holiday doesn't. So it's that sort of thing. And mean for these purposes is what most of us would think of as average. So you're taking the sum of all the values that you're looking at divided by the number of those values to get the average. The median, on the other hand, is you list all the values that you're looking at from lowest to highest, and you take the midpoint. And that's included because it's a better measure in some ways, because it doesn't include the effect of any outliers. So any extremely high or low earners, which would feed into the mean, that's not reflected in the median. Now, the second one is bonus pay. And there again, it's mean and median, but also the proportion of men and women receiving a bonus, because that measure looks at, well, not just how much the bonuses are, but how they're distributed between the genders. You then have to look at the proportion of men and women in each pay quartile. So what that involves is taking everybody in the workforce that you're looking at, ranking them from lowest to highest in terms of their hourly rate of pay, and then dividing them equally into quartiles. So to take an easy example, 800 employees, you'd have 200 in each quartile. And then you have to report the proportion of men and women in each one. And that's helping give a sort of snapshot, if you like, of the distribution of men and women in the organisation. If it's a very male top heavy organisation, then you're likely to be looking at a positive gender pay gap, although obviously it's slightly more complex than that. The fourth item is the optional bit. So you can include narrative, you can include an explanation of the reasons you believe are contributing to the gender pay gap that you've got, and the measures that you're taking, the steps that you're taking to try and alleviate that. And we, increasingly are seeing people really using the narrative as an opportunity to explain the good things that they're doing and the progress that they're making. And then finally, a sort of statement of accuracy signed by a director in the company or somebody of equivalent seniority. So where do you have to publish it? Well, the whole point about the gender pay gap regulations is to sort of shine light on gender pay. And with that sort of transparency in mind, the actual report on that director sign off has to be on your employer website for 3 years in a way that's accessible to all employees and the public. And you also have to upload it to a government website. Now that was a bit clunky to start with, and we'd still recommend not uploading on the last day, just in case it gets overloaded, but it is now working better than it was originally. And finally, on gender pay gap, what are the penalties for non-compliance? Well, it was criticised and still is criticised sometimes for the fact the regulations are a bit toothless. There are currently no civil or criminal penalties for failing to upload. The enforcement is left to the Equality and Human Rights Commission. And like all public sector organisations recently, or most of them, they've been hit by austerity, they're resource constrained, and as far as I'm aware, they haven't taken any enforcement actions so far. And actually, the level of compliance in terms of reporting is quite high, which is probably another reason why they haven't. I can't say whether all of the reports are accurate, of course, but apart from the ones that we do. But in terms of actual reports being uploaded, that is quite a high proportion. So really, what you're looking at as an employer are reputational concerns. Generally, it's an employer brand issue. Future recruits will look. And also, because of the way the government website works, you can sort by sector. And I know that certainly our clients will look at what their competitors and their peers in their particular industry are doing to see how they're faring and the sort of initiatives that that peers are looking at in the narrative bit. The government suggested it would publish league tables originally, but that hasn't happened yet. Again, they've had quite a few other things to deal with in the last couple of years, so that's probably the explanation for that. And as I say, because it's searchable and because the trade press, for example, will go in and have a look for their particular sector, perhaps the government now doesn't feel that that would really add as much value as originally. And then, does it create an equal pay risk? Well, it could do, but not necessarily. And this is where I'm going to start talking about equal pay and the difference. So equal pay is a specific legal concept, and it requires men and women to be paid the same for doing equal work. Now that sounds very simple, but as I said earlier, it's quite a complex area of law. And because of the sums at stake, particularly where you're looking at hundreds, if not thousands of people claiming, the figures very quickly add up. And the reason I say put a question mark against equal pay in terms of its relationship with the gender pay gap is that the reasons for the pay gap are varied and complex. Equal pay will certainly feed into it if there is unequal pay, but equally important in contributing to the gap are societal diversity issues. So there could be underrepresentation of women in management roles at the top of the organisation, and or overrepresentation of women in the more junior, lower paid roles. So, for example, in my organisation, a law firm, typically in a law firm like us, 20 to 30% of the partners will be female, but 95, possibly even 100% of the PAs will be female. So you can immediately see there's a bit of a double whammy in an organisation like that. Part-time working also feeds in. More women than men still work part-time. And this is a generalisation, but it's backed up by some evidence that more women are less likely to argue and push for higher pay than their male colleagues. So all of those things are feeding into the average pay across an organisation. So you can have no pay gap and still have unequal pay, and conversely, you may be delivering equal pay but still have a large pay gap because of the demographic of your organisation and the distribution of men and women across it. Now, if you end up with an equal pay claim, as I said, it's a complex legal process, and also it attracts a lot of publicity. So it can be difficult to be caught up in that, particularly if you're doing your best to try to put things right. And the equal pay focus has shifted now, as many of you will be aware, from the public sector, where 10, 15 years ago, we had a big focus on the NHS when they introduced agenda for change and a job evaluation study as part of that, and local authorities who were doing likewise with new job evaluation studies and pay and grading schemes to match. Now it's the supermarkets in the firing line. So all of the major supermarkets have ongoing equal pay litigation, and that is attracting a lot of publicity for them. So when will a claim come up for equal pay? So what does it actually mean? So usually it's female claimants bringing claims, and I'm going to talk about women claimants because although the Equality Act allows men to claim, the vast majority of the claims are from women. Now, if you are a man working in a predominantly female job group, you can what's called piggyback on your female colleague's claim if they succeed. So if they show that their pay is tainted by gender and it can't be justified if it's indirectly discriminatory, once they've succeeded, the few men in that group can then claim pay parity because their pay is also being brought down for unjustifiable gender reasons as a result. Now, a woman has to identify a comparator, and they have to be a real comparator, not a hypothetical one, and they have to be in the same employment. And one of the preliminary issues in the ASDA supermarket litigation was looking at, well, what exactly does that mean? And can you, if you don't work in the same establishment as your comparator, can you nonetheless compare yourself to somebody? So in the supermarket, it's the sort of female staff in the stores where we all shop, comparing themselves against the predominantly male groups who work in the distribution and depot centres. And one of the ASDA arguments was, well, they can't make that comparison because some of those roles in the depots just would never be in the supermarket store. And that argument has failed. So the tribunal does have to engage in a sort of hypothetical discussion about, well, if that role, even if it would never happen in practice, were to be employed in a supermarket, what would they earn? And if they would still earn the same as they would if they were employed in the depot, then the claimants are likely still to be able to show unequal pay. Obviously, that's not the end of the story because there are other elements, but on that particular issue, that comparison is allowed. And then obviously they have to show they're doing equal work, and we'll come on in a minute to look at what that means, and that their comparator has got more favourable terms. And the thing to remember here is that equal pay works by the Equality Act implying into every contract of employment what's called a sex equality clause. So what it says is, if you can show equal work, unequal pay with a comparator of the opposite sex, and that either a term is less favourable to you or doesn't exist at all, the sex equality clause will operate if you succeed in your claim to uplift your pay to match your comparators, or if it's a term that isn't there at all, it will imply that term into your contract. So it's a contractual implied term basis, which is, it sounds quite technical, but that's how the Equality Act does it and how the Equal Pay Act did it before. Now, I said I'd talk about what equal work is. So there are three ways that a claimant can show equal work. So the first one is like work. So that's where the work is the same or broadly similar. So I'm a cook, Tim's a cook, for example. The next one is work of equal value. So this is where the work done is different. So I'm a cook, Tim's a gardener, just to go with a stereotype. But in terms of the effort, the skill, and the decision making involved in those roles, they are of equal value to our employer. And equal value is decided by an employment tribunal in a claim, unless it's admitted by the employer, of course. And finally, there's work rated as equivalent under a job evaluation study. So the jobs could be, again, completely different. I'm a cook, Tim's a gardener, but our employer has already done a job evaluation study looking at the relative values of the roles and has given us an equal rating. So having done that, we're entitled to be paid the same. So just to illustrate that with a couple of pictures, in the local authority, we had the bin men being used as comparators by carers who were traditionally underpaid. Who knows whether the pandemic will change that? Some people say it will, some people are skeptical. In a different environment, the bottom pictures could be engineers in a construction company out on site a bit more, perhaps being paid more than office-based, predominantly female staff, maybe HR, maybe in-house lawyers. And what are the risks of ignoring equal pay? Well, obviously there are claims, and we'll come to that in a minute, but there are also employee relations issues. In my experience, people are much more willing now to talk about what they're paid than when I went into the workplace. There's much more transparency around what people are earning. And obviously under the Equality Act, you're no longer allowed to prevent people talking about their pay to colleagues if they're trying to find out whether there's an equal pay issue. So there are real employer brand issues here, both for your current staff and your future recruits. Because again, another change over the last 30 years, and particularly with social media, is people are much more likely to look at their employers or future employers' practice before deciding who to apply to and who to accept a job with. Employee relations could spill over into grievances. They are time consuming, as many of you will know. They can be emotive. If handled poorly, they can lead to poor productivity, etc. And equal pay is no different, and actually can be very emotive for people if they feel that they are being sort of taken advantage of, if you like. It will feed into an increased gender pay gap, as we've said, and it could result in claims from employees, which are even more timely and costly and time consuming than grievances. The ASDA preliminary issue that I mentioned previously about comparators went to the Supreme Court, having first been decided 5 years before in the Employment Tribunal. So if you get into that structural kind of equal pay claim, they are very, very long running unless you can find a way to settle them. So if the claim is successful, the claimants will have that clause I talked about implied into their contract, and that inequality that they've succeeded in showing will be modified for the future going forward. So you're going to have a new cost in your business to remedy that inequality. They can also recover for back pay for as long as the inequality has lasted, up to 6 years back from the date they bring their claim. And so that's quite a long time. And that can also lead to significant sums if you've got material numbers of claimants. And that, of course, is all assuming that the employer hasn't managed to block the claim, defeat the claim, by showing that they've got a material factor defence to it. And we'll come on to look at what that is and what that might be in a bit more detail. But basically, it has to be not sex. And if it's indirectly sex discriminatory, you have to objectively justify it, which is the test that we're all used to from every other type of discrimination claim. And finally, in terms of the consequences of a successful equal pay claim, the tribunal must, unless one of the limited exceptions applies, must order the employer to carry out an equal pay audit. And that has to specify the group caught by the audit. The audit, when it's produced, has to identify, as far as the employer can, the reasons that they believe are feeding into potential further breaches of the Equality Act. And finally, the employer has to say what its plan is to remedy and address those potential breaches. And unusually for the Employment Tribunal, when it has ordered an equal pay audit, it's got a sort of ongoing monitoring function, which it doesn't normally have in terms of remedies, but it can keep the parties coming back to the tribunal and keep imposing up to a £5,000 fine for each time that equal pay audit order has not been complied with by the employer. And finally, before I hand back to Tim, I just wanted to touch on ethnicity pay gap reporting. Now, in headline terms, at the moment, this remains voluntary. The most recent independent report looking at this was the McGregor-Smith report in 2017. And she recommended that all businesses with 50 plus employees should have to publish their ethnicity pay gap data. And she suggested that should be done by reporting on the proportion of employees of each ethnic minority in each £20,000 pay band. Now, the government consulted about that a year later and did say that they thought mandatory reporting was necessary, because voluntary reporting had only resulted in, I think it was about 11% of employers reporting voluntarily, which was very low. But they've made no firm commitment to introduce it. The CBI last year encouraged everybody caught by the gender pay gap regulations to report voluntarily on ethnicity pay gap. And that, I think, has demonstrated or produced some improvement, but it's by no means widespread. And there are challenges with it compared to gender pay, because that's binary. But with ethnicity, obviously, you've got multiple ethnicities, and there are practical challenges for employers, some employers, in the adequacy of the data they receive from staff. You know, it's about voluntary declaration, how you identify and whether you're comfortable giving that data to your employer, even anonymously. And some employers have better data than others. And then, of course, there's statistical relevance. If the numbers are very small in a particular organisation, the information may not be statistically meaningful. And then there are concerns about personal data being kept secure and private. So there are real practical challenges with it. But if I were a betting woman, I would say we will get that at some point in the relatively near future. So I'll hand back to Tim.
Thanks very much then, Jane, for that. I will just get back control. And actually, this is ethnicity pay gap reporting's come up a lot in our HR workshops. And I think, yes, that thing about data adequacy is a key thing. A lot of people don't have the data to be able to report on it either internally at the moment anyway. But we have seen a definite movement towards people trying to get their data in order in anticipation of this becoming mandatory in the next few years. So that's the direction to travel anyway. So thank you very much, Jane. And that was really, really useful insights for that. Just for anyone who's joined a bit late, we will be sending out the slides if you at the end after today's webinar. So I'll come on to talking about conducting an equal pay audit, and so the best practice and what sort of challenges there are and how you can overcome them. I guess there's three sort of particular areas to look at. First of all, who's going to do the audit, whether that's someone internal or whether you would use a third party such as ourselves, Pay Data, to do it. The second is around planning and we use the 5-step process set out by the Equality and Human Rights Commission, and that's a best practice sort of process for following an equal pay audit. I'm sure you can get that online if needs be, but the key thing about that is around the scope as well. So before actually commencing any analysis, deciding what the scope of the audit's going to be before you actually then go out and do the work, and then being realistic about, once you've done an audit, what you can actually do and what you can achieve, perhaps financially, and what's achievable. So I'm just going to go on to each of those three areas. I mentioned who, first of all. And there's obviously pros and cons with doing it yourself or using a third party. Obviously using internal resource to do an equal pay audit, you can keep the costs down because you already pay the people. It's a good way of building up internal expertise on the subject matter as they do the audit and do the work. And obviously you can control the pace of when you do it amongst all the other activities and the day job as well. So you've got a bit more control from that side of things. But there are some definite advantages to using an independent external third party to do it. And the first one is a very important point in the fact that you don't actually necessarily, if you do it in the right way, you don't actually have to act immediately after you've done the audit. You don't have to act on the results if you use a third party to assess the costs and the risk. And that's through this sort of confidentiality, which Jane's going to come on to in a bit, around if you instruct a third party through the lawyers, that's part of the legal privilege. And so for a lot of organizations, that provides a bit of reassurance in terms of, okay, we want to sort of see what the size of the problem is, but we'd rather do that without then having to then commit to solving the problem initially, at least initially. So obviously using someone external, you can minimize the time and resources, and actually what that helps means that you're focusing what time you've got and resources on actually on the actual action plan from the equal pay audit, rather than doing the number crunching. And then finally, obviously, if you're using an expert who's been doing these sorts of things for many years, you're tapping into best practice, you're making sure you're not going down any blind alleys and avoiding any sort of errors in the process as well. So there's obviously pros and cons to each. That's the who. Then there's the sort of planning, the how. And I mentioned about the 5-step process, the EHRC process. Now, a really important part is sort of steps 1 and 2 before we actually get into the meat of doing the analysis. And I'm going to come on to a bit more detail about step 1 in a minute, around defining the scope of the review, what data you've got and what data you need. Step 2 is around categorizing the data. So picking up on what Jane was mentioning about comparing apples with apples, Tim as a gardener versus Jane as a cook. So it's how you defining how you do that, and that's where you have a check whether you've got a job evaluation system in place to be able to do that for the rated as equivalent analysis. Once you've determined that you can do that, the information's available, then it's coming on to analysing the information and identifying if you've got any pay gaps between the sort of different categories. If you're lucky enough that there's no equal pay gaps, then you can go straight to step 5 without passing go, and review and monitor periodically to make sure that, I think that's important, to make sure that you sort of keep up to date with whether you're okay. If you do have identify some gaps through your audit, it's then establishing what's causing those gaps. Now, you might be lucky in that you're able to justify that those gaps are free from discrimination. Again, if you're able to do that, you can go back to reviewing and monitoring periodically. If not, and that there are some gaps which could be construed as discriminatory, then it's around developing an equal pay action plan to resolve those gaps and those differences. So this is the sort of step process. And I'm just going to talk about step one, which is, as I said, one of the common issues people have is going straight to step three. Let's go and do an analysis without properly thinking about steps 1 and 2. So there's a number of useful questions to ask yourself when you need to define the scope of an equal pay audit. And we work with a lot of organizations and doing this initial first step, almost like a diagnostics piece of work. And we ask these sorts of questions. So first of all, as an organization, how are you structured? Do you have a single site or multiple locations? Do you have multiple terms and conditions for different groups of employees? Do you have collective agreements in place? All this might have an impact on whether you've got some pay differentials there and an equal pay gaps. Secondly, what sort of pay system do you have? So do you use spot rates dependent on sort of incremental rates, or do you use pay ranges? If you use pay ranges, are they overlapping as well? In terms of pay, do you have any sort of regular payments? So things like a London weighting, for example, which everyone gets if they're based on certain criteria. Also, do you pay bonuses? If you do, who gets them? Who's not eligible for them? And also, how accurate is the information that you hold? Obviously for base pay, most people hold that on a payroll system, but bonuses are often held in different systems, on spreadsheets, all sorts of places, and that information is sometimes a little bit more difficult to get at and maybe less accurate as well. So, it's asking about sort of what sort of pay system do you have as well. The other thing to ask, which is an interesting thing, is are there particular parts of the organization where you've got the largest, where you perceive there to be the largest equal pay risks? So you might be have particular large male or female populations in particular areas or locations. You might have one location where you've got different employees on different T's and C's, so that could potentially create some pay differentials there as well. So that's a useful question to ask to help you prioritize. If you've got a large organization, do we need to look at some specific areas first? And then there's obviously around how the data is organized. So, is it available? Where would you need to get your the pay data from? How complete is it? How accurate it is as well? Because obviously the accuracy of the data is going to have a big influence on the sort of accuracy of the results and the validity of the results as well. Now, moving on to, we're now starting to move into step 2 of the processes, which is how you categorize your data. And it's a very useful question to ask is how do you group your roles together in terms of the nature of the work, the type of the work? So job families, career families, people use those, or just sort of functions or directorates. So there's that side. And then lastly, do you have an analytical job evaluation, a job grading system in place to be able to determine the size of the role, the seniority of the role? And that's very important, that last point. So you ask these questions, and that helps you define the goals of your equal pay audit, being realistic about it. And first up, if you don't have a full job analytical job evaluation system in place, it'll really make it very difficult to accurately analyze whether you're comparing apples with apples. So, and we highly recommend having that in place. And in fact, that's one of the reasons why people come to us to put a job evaluation, job grading system in place, because they want to do an equal pay audit and they can't at the moment. So just as an example, if you're using a broad-banded, maybe you've got 6 grades across your entire organization, a broad-banded job evaluation system in place, the issue we've had and challenges we've found in conducting equal pay audits is that what that sometimes does is groups roles together where there are different levels of demand, and they're grouped together in the same broad band and analysed in the same broad band. Now, because the roles, the different roles there might have different levels of demand, you naturally, the market determines that you pay differently. The internal market means that you might pay differently. And if you're grouping them all in together, it will show you to have what we call false positives, some real differences there, when in actual fact, you're not quite comparing like for like, apples with apples. So that's why it's so important to have something rigorous in place to be able to assess a level of demand for roles. I mentioned this a little bit earlier about looking through, if you're asking those questions about the sort of data, the accuracy of the data, what that what you might conclude from that is actually, rather than doing an audit which covers the entire organization, let's look at some specific areas and bite off what's realistic for us to be able to solve. So yeah, let's look at where the data is going to be the most accurate, or perhaps where our operational staff, where we employ the most people. Let's look first of all at that area rather than trying to bite off the entire organization. It's common for organizations to look at just purely gender pay and base pay initially, and then perhaps with a view to saying, okay, let's look at ethnicity, let's look at disability, other areas at a later date. Let's look at total cash, or even indeed total compensation later on. But it may be as a first go at an equal pay audit that you don't have that information altogether, or it may not be completely accurate. So it's determining, what's the best way, and it doesn't have to be that you bite off in the entire organization. And then finally, through conducting audits for over 15 years, we've seen many challenges for employers. And I guess these are some of the sort of the key ones there. The first one is just getting it off the ground in the first place and getting buy-in from senior management. That's one of the biggest barriers to conducting an audit. Senior management don't really have that buy-in for you to do that at the outset, and it's persuading senior management that you need to look at this. So that's the first one. The second one I've sort of covered off about the comparing like for like. If you don't have that grading system in place, it's very difficult to do that analysis, and as I said, the outputs will then show some false positives, show a worse situation than might actually be a case, and that obviously then creates more work further down the line to sort of unpick that. And then lastly, often organizations, if they do an audit, then if they do it across the whole organization, they might be a little bit overwhelmed by the results. They've got lots of analysis to look down, lots of places where there may be some gaps there, and they just don't know where to start. How do you prioritize where to take action? And that's sometimes the case as well. So hopefully you found that useful. I'm now going to hand back to Jane to talk about the role of legal privilege in conducting equal pay audits. So Jane, over to you.
Okay. So those of you who've been involved in litigation will know that at a certain point in the case, the parties will hit the disclosure obligation, and that means disclosing documents that are relevant to the issue in dispute to the other side, because in the UK we operate litigation on a sort of cards on the table basis. So whether the document's helpful to you, unhelpful to you, helpful to the other side, unhelpful to them, if it's relevant to an issue that is disputed, then you have to say that you have the document, and when it gets to the next stage, which is producing copies of the documents, you have to produce those to the other side for inspection, which these days involves emailing them to the other side rather than providing hard copies. If a document is privileged, then you still have to say you have it, but you don't have to provide a copy. So the contents are hidden from the other side. So there are two types of privilege to be aware of. The first is legal advice privilege, and that is relevant regardless of whether there's any ongoing litigation. So the idea there is that clients should be free to take advice from their lawyers as long as it's in a relationship with confidence, and know that if there's a future dispute about the issue that the advice is being given about, that the communications between them for that confidential giving of advice, receiving it and giving it, do not have to be shared with the other side. Litigation privilege, on the other hand, is only relevant where litigation is either ongoing, there's already a claim, or you think that it's going to be lodged soon. So it's in contemplation. So it has to be more than a kind of theoretical potential possibility, which could apply to anything. It's got to be something that you think, you know, it's been intimated, or somebody's actually said they're planning on doing it. It's that sort of level of contemplation. And that can protect communications for documents that are created once the litigation is contemplated or started between the lawyer and their clients and third parties who might be helping, and like witnesses, for example, who may no longer be employed by the client at the time of the litigation. Now, the dominant purpose in both of those cases, in the first one has to be receiving and giving legal advice, and in the second one it has to be the litigation on the issue that's in dispute. And also in both of those situations, it's really important to understand who the client is. That's why I've underlined it, to remind myself to say this bit. There is case law which is probably considered quite unhelpful for litigators, which is the client isn't necessarily, and often won't be, the same as the organisation which is paying the lawyer's bills, frankly, and is the name on the litigation pleadings. So it's going to be a smaller subset of employees of that organisation who are tasked with getting the legal advice or running the litigation, or need to know the advice because of their position in the organisation, like the board, or because of the job that they do, they need to know about it. So it's really important at the outset to understand who the client is, because as we'll come on to look at, if you share the information outside that client group, then privilege can be lost. So the definition of documents is very, very wide. It's the other thing to flag. So we're no longer thinking just about pieces of paper to the extent that anybody uses those anymore. It's basically anything on which information of any description is recorded and can be transcribed. So voicemail messages, text, WhatsApp, links, Slack, anything like that, any form of electronic file, basically. So it's a very wide definition. And each copy is considered to be a separate document. So you can see that a document that's privileged, if you share it with somebody who's not in the client group and you share it too widely, that copy will lose privilege. And the danger with losing privilege or waiving privilege is that you can't sort of cherry pick. So the risk is, and this is a complex area with lots of case law around it, but the risk is that you can't confine the loss of privilege to that sort of particular email. It goes wider to that email exchange, which could be very lengthy, or to a whole kind of issue in the dispute. So there is a way through this, which again we don't have the time to cover in detail. But if you are working with your lawyers for the dominant purpose of taking legal advice about your equal pay exposure, then if you have the lawyers subcontracting with an organisation like Pay Data, and the information comes to the lawyers to help assess the legal risk, then it can be brought within legal privilege. But as I say, it can be easily lost if you don't set things up properly from day one, and everybody understands that. So it's an important consideration at the outset. It is a matter of substance, not label, although best practice is to label things legally privileged if you consider that they are. It just helps later in the disclosure exercise. And the other thing I would mention is that if you do things under privilege, and we get this with investigations as well into grievances, you can't sort of have your cake and eat it and then rely on that information to defend a claim without losing that privilege. And as I say, you may not want to do that, and you probably won't want to do that over everything. So you need to think carefully about at which point you're going to create open documents, which would then be used to defend any litigation. And so sometimes, for example, in gender pay gap reporting, you might want to do a dummy run for looking at what's there, gauging the risk, and then do it openly separately. So moving on to actually defending and managing equal pay claims, you will in most cases have an early warning sign. So you've got the internal grievance process, obviously. ACAS early conciliation may also flag this. And if you're dealing with individual claims, then they are potentially resolvable in the way that any other individual claim would be. And often for individual claims, what we see is the equal pay element is kind of caught up with something else. It could be, you know, somebody's been dismissed and they decide to say that actually, or argue that they haven't been paid equally for the last however many years of their employment either, and their dismissal's been discriminatory. So it's usually caught up in something like that, but it doesn't have to be. You can bring an equal pay claim during your employment and solely about that equal pay issue. If you end up on the receiving end of the claim, the vast majority of them will be in the employment tribunal. They can be brought in the county court, but there are pros and cons of each. The county court obviously has a different fee regime, no fees in the tribunal anymore, and a different costs regime. So generally in the tribunal, even if you lose, unless you've behaved unreasonably or otherwise abusively, for example, you won't have to pay the employer's costs. So it's quite attractive from a cost perspective. But where a county court can be beneficial if you're a claimant and you're a bit late to the party, is that the time limit for lodging a claim is much longer. Remember I said it's a breach of contract claim, essentially implied contractual term? Well, the limitation period for that is 6 years. So you could have left employment 5.5 years ago, 5 years and 11 months, you can still get a claim in. In the employment tribunal, it's 6 months from the end of the employment, so it's significantly shorter. And the three essential issues are, is there equal work, which we've looked at? Is there unequal pay? If both of those things are present, what's the reason for the unequal pay? And this is where it gets sort of interesting and complex in terms of equal pay litigation. So I've talked about individual claims being, you know, relatively similar to non-equal pay ones. But where it gets very complicated is the collective claims. So the sorts of things that the supermarkets are facing at the moment, where you might have hundreds or thousands of claims, usually union-backed, not always, but usually, sometimes crowd-funded. And of course, they're going to be much harder to try and resolve without going through the legal process, simply because of the numbers and the scale of it. You know, some people may be interested in settling, others may not. So it's a difficult issue. And of course, the more people there are and the greater your exposure, the harder it is to potentially find the money to settle. Some of these liabilities are extremely, extremely significant. So if you're in a collective situation, which is what I'm going to focus on now, the first thing the tribunal will do once the claim and the defence have gone in is to have an early case management hearing. So what they'll be trying to do is look at all the claims with the help of the parties and say, okay, well, can we group these into groups of claimants who are claiming essentially the same issues against the same comparators? And you'll end up with what's called different multiples. And for each multiple, what you're trying to find is a lead claimant who will be the person that gives evidence, whose claim will go ahead first, and then everyone else's claim is stayed. So it's a sensible way of sort of managing resource by not trying to have everybody involved all the way through. And you also get at that early case management hearing, or sometimes it's delayed a little bit to another one, a sort of discussion about, well, which order are we going to take those issues in? Equal work, unequal pay, the reasons for the pay. And that's a strategic decision that you need to consider early on. So, and that's going to depend on the strength of your position and the evidence that's available. And as Tim mentioned earlier, sometimes the data just isn't there. If it's a historic pay issue, sometimes that's lost. I had one client that had a fire, and I'm not sure the other side ever truly believed that, but there was a fire that burnt all the old records. And so that can be a significant factor as well. But for example, if you're an employer that feels you're on strong ground on a material factor defence and that you're going to be able to show that the reason was not in breach of the equal pay laws, then you may argue that that should be taken first and try and persuade the tribunal that that's a knockout issue. Because if you can show that, there's no point going through the equal value process, because even if the jobs are of equal value, you're still going to be able to defend the claim. Now, equal value is difficult for claimants. They often plead it in the alternative to job rated as equivalent, or have no option if there is no job evaluation study to rely on. But under the tribunal rules, there's a separate and very lengthy process for helping the tribunal get the evidence of the relative values of the jobs. So there'll be a number of hearings. An independent expert is usually appointed. There is a preliminary stage of engaging with claimants and comparators and managers in the organisation to get agreed job descriptions, which the independent expert then uses to produce a report. So it's quite a lengthy process, and therefore, is expensive and time consuming. Job rated as equivalent claims can be quicker because the job evaluation study is already there, unless of course that's going to be challenged, which it sometimes is. And the other point to make on job rated as equivalent claims is claimants can only rely on it and its rating from the date it is done, comes into effect. But what we saw and sometimes still see in the local authority cases, what we saw was the new job evaluation study and pay and grading scheme was brought in, but the claimants were saying, well, thanks for rating me equivalent to this bin man now, but actually our jobs haven't changed. So going back before the job evaluation study, I'm going to bring a claim for equal value because our jobs, nothing's changed in terms of the jobs we were doing, and therefore they must have been of equal value before you analyse them as such in your job evaluation study. And then finally, the material factor defence. So this has to be the real and significant reason for the difference in pay. And as I said earlier, it can't be sex itself. If it's indirectly sex discriminatory, you have to be able to objectively justify it as an employer. But there's no list actually in the Equality Act of what a material factor could be. But case law tells us that it's generally things like relative seniority and experience of the claimant and comparator, relative qualifications. It could be geography. So Tim mentioned earlier London waiting. That could be the explanation. It could be pay protection. So people are trying to bring in a new pay and grading scheme, but that has to be done in a way that doesn't sort of disrupt everything. And perhaps the only way to get it through is to build in some pay protection for the traditionally male roles, for example. And then we sometimes see market forces. For that one, you have to be a little bit careful with, because if the market itself is sort of tainted by, well, this is women's work, so we don't have to pay much for it, then that can be difficult to rely on. But as you can see, there are multiple sort of facets to it. It's long running if it's collective generally, and settling it is harder. And the strength of your position will always depend on the data that you have and the evidence that you can adduce. If you can't provide that evidence, then you're going to be in difficulty. So I will hand back to Tim.
Thank you very much, Jane. Thank you for that. It was really interesting, those things you're sort of mentioning there, particularly the sort of material factor defences as well. I think a lot of people sort of say, what can we do to mitigate that? We do have, I think we had some questions come to us. You mentioned early on, actually, Jane, about if a tribunal can order an employer to conduct an equal pay audit, but there are some exceptions. What would those exceptions be where they don't order that an equal pay audit is run?
Yeah. So there are 4, and they are written into the regulations because, as I said, the tribunal must order an audit if the employer loses, subject to these exceptions. So one is that there's already information from an audit that the employer's done in the last 3 years, so that in essence there's no point ordering another one because one's already been done recently. The second is it's clear already from the case without an audit what action is needed. So that might be in a kind of in a more self-contained individual case, for example. One is there's no reason to think there are other breaches. And again, that might be for similar reasons. It's a very isolated issue and no reason for concern. And then the last one is that the disadvantages of an audit would outweigh the benefits of it. So that might be something like, well, maybe the business is, or a part of the business is about to be sold. There's not much point doing it if actually the workforce is going to be broken up, and it would be expensive and not much to be gained from it. Could be something like that. They are, I'm not aware actually, although they're there, I'm not aware that there's been any audit that's been publicised as ordered. So it's not many equal pay claims actually get all the way to the tribunal ultimate finding. There's lots in the system, but lots of them end up settling, and therefore the audit wouldn't kick in.
Okay. I've got a couple of questions actually around, thanks for that, Jane, about around protection. So I think Anna's mentioned something, does equal pay take precedence over 2P protection of pay rates? And I think we've had another question, a similar thing about, if you've negotiated a pay, certain pay rates with a trade union, does that offer some form of protection as well? So I don't know if that's similar or not. So I don't know what your thoughts are, Jane.
Sure. Well, if we take the second one first, that's quite an easy one to answer. The fact you've agreed pay rates with the union is not a get out of jail free card. Unions themselves can be sued, and in fact were sued in the local authority litigation for agreeing essentially discriminatory pay bargains favouring the traditionally male workers, the breadwinners, over the traditionally female roles. So it won't be a get out of jail free card at all. But
about 2P,
yeah. So you've got a clash really, haven't you, between two sets of legislation. And if you think about what I said earlier when we looked at material factor, it's got to be the real and material reason for the pay. 2P could be that reason. And if it remains the reason, because you haven't looked at the pay rates since the 2P transfer, for example, there's been no opportunity to address them, then 2P will still take precedence. And in fact, even in that pay review, it could do. So 2P can operate as a material factor, but what I would say is that if you've inherited a workforce and there's a clear equal pay issue, the 2P protection won't last forever. And actually, going back to that employer brand point, you may not want that to allow that situation to continue in any event. You may want to have a look at it earlier. And the 2P defence would come in the event of a claim. You might want to rely on it, but you wouldn't necessarily, as an employer, want to allow that situation to carry on if you can afford to remedy it. Okay.
Another actually interesting one, I'm talking about material defence factors, and actually it's something we've included when we've done equal pay audits as an analysis, is around performance. So if you've got two people working in the same job or job of equal value, but they're on different performance and their pay is different, therefore can that be used as a material defence?
Yeah, that's a really interesting one actually. So I did a talk about 15 years ago, and I got into quite a spat with somebody who's very in the great and the good of the equal pay world, making this very point. And the sort of purist view is, well, once you've done a job evaluation study, for example, you might have sort of performance enhancements, but when you're looking at basic pay, it shouldn't come into it. The pay is for the role. So performance as a material factor defence is a difficult one for that reason, because it's sort of a little bit artificial. And I think it's because a lot of the structural equal pay claims are for roles where, with all due respect to them, there's a limit to how much difference somebody can make to the organisation in that role through performing their role better. I think in other jobs, it might be a slightly different equation. But so I think performance is challenging as a material factor defence.
Okay. I'm afraid we have got one or two other questions, but we'll, as I said, I mentioned, we'll answer those afterwards and send that out with the slides. We've hit our hard stop at 11 o'clock. Hope you found it very useful, everyone. Thank you once again, Jane, for your expertise and your knowledge. I found it very interesting. Personally, I've learned a few things as well. So thanks again, everyone, for joining. I hope you found it useful. Any questions, please email us. And as I said, we'll send out the recording link and the slides afterwards. Catch up with you again soon anyway. So thanks again, everyone. And thanks again, Jane. Take care now.
Thanks. Bye.
Bye-bye now, everyone.